Yeah. Well, and last week we thought, oh, there's not that much, and then things started just happening like crazy. So.
Yep.
Be interesting. Chase, are most people in that are out there?
Yep.
All right. Well, not as many as sometimes, but it sounds like a good group. Thank you all for signing on. We appreciate it. Let's get this show on the road. I'm Lyle Hanna with the Hanna Research Group. We're delighted you're here to join us for the Crisis Management for COVID-19 Phase 40. We've done a lot of these, haven't we? But we're taking a little different twist on some of these because there are other things that are really hot right now. So we're going to give you some update on COVID, but we're also going to talk about what employers need to know about the changing drug landscape. What is that all about? You know what? We've got neighbors that are allowing smoking of marijuana. It's becoming more prevalent, and the use of CBD and other things that kind of make the testing somewhat of a challenge. And we've had enough people call us and ask us questions about it. We thought, let's go and do a program on it. Now, I got to tell you, we don't have all the answers, but we've got, we think we can help you get more comfortable with the subject, know what you're up against. There are a number of things that are changing. And so we thought now's the time to get on it and start educating people on it. We've got to do a little a survey that I think will help us get started in the right direction. Allison, let's put up that survey. Everybody give us their feedback on this survey while others are joining us. And let's see what kind of experiences people are having out there. Here we go. Is your organization facing issues around marijuana testing?
And they're going to have to answer number 2 with one of them. It won't let you submit unless you answer that one.
Yeah, sorry about that. They had changed the interface on me, and I thought that was automatically deleted, but apparently not.
Whoops, so just pick one of them. It won't matter. We won't hold it against you. And when do the other ones come up, Allison? You're muted.
Sorry, I said they're all individual questions. So once this one's completed and we share the results or not, as we're going to, then the next one can be shared.
I can end and share the results if you're interested.
Go for it.
All right, ending it now.
All right. How about that? Is your organization facing issues around marijuana testing? And boy, the biggest answer is no. We haven't had many positives, aren't looking to make any changes at this time. But 30% is unsure, still learning. And 20% no, we're required to test for marijuana based on industry or other related requirements. So we have no options. All right, what's the next question? All right. Do you currently drug test your prospective employees as part of your new hire process? Worried that second one keeps staying there. If you just signed on, looks like some people have, just click that second one, either one, it doesn't matter. Something we tried to eliminate and it didn't go away. So.
5 more seconds.
Okay, do you currently drug test your prospective employees as part of your new hire process? The answer is yes. The test includes marijuana, 59%. Okay. Interesting. Only 39% no drug testing at all. We'll talk about that. And the last question. When do you drug test?
And that answer, depending on how you answer, and you must answer truthfully, we have truth detectors, may change after you hear what's going on. Just telling you, I don't care what your answer is, your answer might change.
All right, what do we have? And when do you drug test? Reasonable suspicion sounds like the main one, 61%, but 56% are doing pre-employment, and then post-accident, 49%, and random drug testing, 33%. Wow. Okay, only 21 don't do it at all. So very interesting. Well, we want to know kind of where we all stood before we jumped into this. So we're going to talk about drug testing. We've got some interesting stories to share with you. And certainly this thing has gotten a lot of attention. We're going to talk about legal testing concerns, and then we're going to talk about some legal regulations that are hot now that we got to pay attention to. So, Allison, take it away.
All right, thank you, Lyle. Yeah, so to start off, where a lot of this is going to be focused around marijuana today. Because that is, what has been changing really quickly across the nation, the regulations around that. But my plan today, Jim is clearly going to be talking about the legal. So our goal is to talk a little bit more about kind of business considerations and give you a framework for thinking about the options. Just kind of revisit, why people drug test in the first place and what your organization's goals are around drug testing so that you can make sure the policy that you design both fits your needs and fits the legal requirements. So why are we talking about it now? So there's a lot of people are experiencing this. I'm sure you all have seen it in your organization. There's a scarcity of qualified candidates in the market. That is not purely because of people not being able to drug test. I mean, there's health concerns. People are still needed at home. There's expanded jobless benefits. Since all employers are looking for people, the demand and probably the people headhunting your people and making them offers has increased. But thinking about the fact that there are and then drug testing may limit your pool even further is worth considering. So some employers are considering changing their drug testing policies or dropping marijuana from the drug panel. Amazon, Marriott, other companies have already done that for some of their positions. And state laws and regulate on marijuana use. So some states do have limits on discipline or refusing to hire an employee after they test positive for marijuana. I shouldn't say a lot, but some states do have even banned employers from adverse action based on those. I kind of want to do is rethink the when and the why. So a lot of times whenever you go into an organization and you say, do you drug test? The answer is either yes or no, and when you say why, it's because we've always done it this way. Either we've always tested, so we keep testing, or we've never tested, so why start now? So just want to kind of think through kind of what is the reason that if you are drug testing, you're doing it? Is it to reduce the risk of litigation if you have an incident and you want to be able to, prove that you did your due diligence in hiring? Is it to prevent accidents and improve safety in the workplace? Is it that it's mandated in your industry, so you really don't have a choice? Are you trying to create a certain type of culture, like maybe one that is extremely professional and where drugs are
Somebody
where
kind of
drugs are.
break
No,
it.
sorry. I felt like I was on drugs for a minute. Or do you have a
That
really
was my
high
fault.
risk?
I'm sorry.
Or do you have a really high risk workforce? So are you hiring from populations where it's very likely that there may be drug problems? When you test, of course, is also something that needs to be considered. So pre-employment, post-accident, random, and reasonable suspicion. We saw from the poll that random seems to be the least common. Pre-employment, post-accident, reasonable suspicion are very, very common. But you also want to think about what you are getting out of this drug test. What is the value of drug testing your employees? So of course, there's a cost associated with testing anyone in any circumstance. Whenever you're hiring, it can slow down the process. So the speed of completing your new hire process or getting that testing done, the candidate experience in having to go and get the test done. No one wants to pee in a cup. I think we can probably all be aligned in that. So are you actually getting enough value out of making your new employees do that it's worth having them go have that kind of negative experience? What type of culture are you trying to create? So again, if you choose to drug test, you may be trying to create a culture that is very professional, buttoned up. Drugs aren't even on the horizon. If you're in a more creative or more, office-based workforce, are you looking for a culture that's a little bit looser, a little bit more creative and wild, who you wouldn't necessarily have a problem with them partaking legally? What are you trying to protect against? So again, think about the risks that you're actually trying to avoid and when you test. So we already talked about those. So a couple of things with marijuana that makes it more complicated. So the length of time that marijuana stays in your system, of course. So you could have a situation where you find the perfect candidate, you make them a job offer, they come and they fail the pre-employment screening because of marijuana. Maybe they do that because they recently went on vacation to a place where where marijuana is legal. And so they legally partook of a recreational drug, not on work time, in no way associated with their job or performance. But then they come back to your organization and test, and because how long it can stay in your system, they fail. That may not happen often, but it still is something that potentially could be an issue. If someone does it recreationally after hours, again, in a legal environment, a state where that is legal, and it has no influence on their work, they're not coming to work impaired, is that really an issue for you as the employer? And then again, legality. So where you are is going to make a huge difference here, and where your employee is. And then the varying state laws and regulations. So some states do allow medical marijuana use, recreational use, and then the limits on discipline and adverse action. Let's see. Oh, Jim's answering some questions. Awesome. So real quickly, a couple of other things to consider. So you can also always build into your drug testing policies or drug policy in general, requiring employees to report criminal convictions and or charges related to drug statutes. So that's something that whether you test or not, you can kind of help monitor what's going on in your workforce related to any drugs. You never have to tolerate on-the-job use, whether it is legal in your state or not, if it is causing impairment to their work. Now, there are instances where you could be in a state where it is legal and it does cause impairment to where the employee, maybe they have medical marijuana, they are authorized to use it, but it still impairs them to the point where it is a safety concern. So you can still address that. You do not have to, they don't have a card to just do whatever they want because they have a medical marijuana card. You are still able to address that if it causes impairment and makes their work, unable to be done or unsafe. And then you can always, if you choose not to pre-employment test, but you decide to maybe do for reasonable suspicion or random drug test, you can always move forward with some type of disciplinary or adverse action if they refuse to take the test. And your policy is that they are required to do so when asked. If you go with the reasonable suspicion, which it seems like a lot of you do, training managers and supervisors to observe the behaviors that could lead to reasonable suspicion testing are going to be really important. So make sure that they know to look out for strong odors, questionable movements, twitching or staggering, dilated or watery eyes, flushed, confused, or blank facial expressions, slurred speech or an inability to verbalize, and if they are argumentative, irritable, or extremely drowsy. So any of these things or anything that is very out of character for them or that is impacting their work, meaning their work product or productivity is suffering. All right. And so I included in here a couple of rehabilitation sample statements because we also have, again, employers that whether you test or not will have some type of a statement about rehabilitation. So they may be willing to help and reasonably support associates requesting assistance in dealing with drug or alcohol problems if the assistance is self-reported and not a result of an incident at the workplace or a failed drug or alcohol test. Now, some states, I believe California especially, does have kind of a voluntary drug statute where you're required to support them, at least in a reasonable way, kind of similar to ADA. But states that don't have that, you can also still put these policies in if helping rehabilitate your employees is something that you're passionate about. So a return to work agreement, for example, if they have a violation of the drug-free workplace policy, you may, it does say may, not will, but may be offered an opportunity to participate in rehab. And they would need to sign the agreement as a condition of continued employment. So you have a lot of different ways that you can structure this to help your employees if that's something that you think is important. All right, and the next steps, basically just consider your applicable state laws and industry requirements. Make sure you're evaluating the goal that your policy is trying to accomplish and update and communicate your policy as appropriate. The best policy in the world does nothing if people don't know that it exists or know how to answer questions about it or administer it. So I think, yeah, kind of a quick overview. Like I said, just a framework to think about. And Lyle, you mentioned you had somebody with a fun story about this?
Yeah. We've been taking calls on this. I've been talking to a variety of people, but somebody I was with real recently had a very unique story that has some pros and cons to it. And I think the way they pursued it is really great. And it still remains to be seen how it'll all come out. But we have Jennifer on the phone from Bluegrass Airport. Jennifer, can you hear me?
Yes, I can hear you. Can you hear me?
Yeah, Jennifer Kelly has been the head of HR at the airport for several years. And she's got kind of a unique situation that she has certain regulations that we don't all have, but a lot of us have different federal standards we have to meet. And of course, airports have their own set of federal standards. So Jennifer, why don't you tell us what's going on out there and kind of where you are on this? Because I think it's just fascinating. Other people might be able to relate to it.
Well, and usually I like to give you a solution with a problem, and I don't have a solution right now. So I apologize up front, but I do think it's helpful to hear that you might not be alone out there. We have an employee with Crohn's disease, was taking a expensive medication, something like $2,500 a month. And that was helping with the Crohn's, but it was actually doing damage to his liver. And his doctor said to him, this is improving your quality of life, but it's also going to shorten your lifespan if you continue on this. And somewhere along the line, he was introduced to the idea of CBD oil, which you probably have employees that are using products with CBD oil in it and not recognizing that the THC can show up on a test. Because when you do a drug test, that marijuana test is not for marijuana, it's for THC. But anyway, the doctor, or somewhere along the line was pointing that direction, he has found that doing CBD oil under his tongue twice a day relieves the symptoms of Crohn's almost completely. Very rarely needs the drug that's the $2,500 drug. So his life expectancy is better, his health is better, which is great. It also means that we don't have that claim on our health insurance of $2,500 a month, which is great. The downside is we are required to test for THC because we're an airport, and we have worked with him and he does test positive. My hope had been to write a policy where we could create a baseline for him that essentially said, as long as he's within this range, we know it's THC, but if it's above this range, then it's probably marijuana. Not the case. We have been working with him to test for a period of time, and it's all over the place. And knowing that he's doing it regularly makes me wonder how accurate the testing is. But there'll be months where it's not showing up, and there'll be months that it's high and sometimes it's low. So it is a huge challenge for us. And I think more of us along the line are going to find that excuse for marijuana. Finally, somebody's found one that works. They can say they're doing CBD oil, and it's not just poppy seeds. It's the CBD oil, and it's legitimate.
And Jennifer, tell us what the whopping price tag on the CBD oil.
$4.
$4.
$4.
And Jennifer, we're going to talk a little bit about this, and I might have a little bit of help for you, but I don't know your situation, so we'll see. But that's the reason why I suggested we do this now is, and you guys are, I'm a bury the lead here. I'm going to jump forward. We literally just had Virginia go 100%. In 9 days, 10 days, Virginia goes 100% legal, from 100% illegal to 100% legal, and they're all along the western border. And so you've got a serious situation with a very close state adopting this, and CBD, THC, the difference between them is minimal, but there is one area that hopefully I can help out with. Possibly, don't quote me on it, but possibly you can look into it. But there's a lot of problems. We want to talk about this now because wait till you see the number of states where it's legal, because if you don't check it every day, it literally changes daily on who's allowing what cities are ignoring the federal government, what states are ignoring the federal government, what cities are ignoring the state government. I mean, this whole thing is going to become a nightmare for businesses, and your situation is not unique. I've dealt with that for years, so we're going to talk a little bit about that.
The other thing I want to add real quick is there was a case you're probably aware of in Powell County. There was an EMT that tested positive for marijuana, was using CBD. She was fired for testing positive, and she went to court and got her job back. So there is standing for being allowed to use THC products with that case, but I don't know how we test for marijuana without testing for CBD.
Yeah, and I've got, stand by, because I think I might have one. I don't know. Maybe don't get too excited.
Okay.
But I'm trying.
Thank you.
All right, Jennifer, thanks for sharing. Well, when you look at the statistics from our questions early on, you can bet that other people have some challenges like that. So let's have Jim give his presentation. If we have any time at the end, if other folks want to share their stories, we'd love to have them. Jim.
All right.
Thank you.
So
thanks, Jennifer.
Before I get into it, let me go ahead and tell you, everybody who's pre-screening, pre-employment drug testing, you might want to stop. You should be doing something that I've been preaching for a while, and it's become reality. It's called a post-hire pre-placement. So now you've established an employment relationship with this individual that then allows you under HIPAA and other considerations to address this person. So you're going to pre-place or pre-select them, but you haven't placed them into a position yet until you can finish the drug testing, background, functional capacity evaluations. If you have any lifting, bending, twisting, free advice for you. Make sure you offer the job, but then do the pre-placement testing. That's FCE, functional capacity, drug testing, and so on. The other thing is I had a tremendous number of companies I worked with that used to think it was a great idea to do their drug testing in-house. So they set up a little drug testing area, had the person go urinate in a cup, then the manager would go get it, drug test it. That should be probably stopped unless you're in the medical industry with a nurse involved. And I know that's a big expense, but with all of these rules getting ready to really create problems, I don't think you want to be on the wrong side of that. So that advice I've given to the companies I've been working with that actually screened people, they would They followed my guidance. It was a post-hire pre-placement drug test. So they would interview the person. They would interview the person. They would make a decision as to whether they wanted that person involved, and then they would go screen them in-house. Not a good idea anymore. So here we go. And by the way, if you're waiting for the COVID update, don't worry. You see, there's a whole bunch of stuff we got to cover. The COVID update, the OSHA update, the EEOC. There's a whole lot of stuff that happened at the end of June, end of May, middle of June. We're going to cover all of that as well, but we promised we were going to do this in a little different order. So, implications for human resources and businesses. When I first raised this topic to Lyle's like, I don't want to talk to businesses about drugs. I don't want to talk to businesses about marijuana. That's just wrong. And I said, HR has to deal with this. And he says, I know, but how do we do this in a way that it doesn't look like we're promoting it? And I said, we're not promoting it. This is a nightmare. And what you just heard from Bluegrass Airport is a very serious issue we're dealing with more and more every day. And it's not going to get better. It's going to get worse because every state around us is adopting either medical, full. There's only 3 states in the country now that have 0. Kentucky is, and I disagree with this, but Kentucky is considered a marijuana legal state only because we allow hemp with CBD less than 0.3% THC. If you don't know what all that means, basically what it means is if you derive your oil from the cannabis, it comes out as THC. If you derive it from hemp, it's supposed to come out as CBD and not as THC higher than the 0.03% or whatever that percent is. And I know I probably just got it wrong. Whoops. So the questions are this: what's illegal? What if someone goes to another state where it is legal? And you heard Allison talk about this. What if they went to a state where it was legal and they even unknowingly consumed it because it's legal there? Whether it was in this is the crazy thing. If you go to Denver or Colorado, San Francisco, there are beers made out of marijuana, THC. So people could unknowingly take the drug in a state that has legalized this and just consume it, whether it's in brownies, whether it's in food, whether it's in beer or alcohol of any type. So there's a lot of issues. Are they currently under the influence? If they're not, there are some real serious problems. When do you drug test an employee or prospective employee? What questions can be asked pre-employment, post-hire pre-placement, post-employment? Those are the types of things we're dealing with. What types of drug testing procedures are being utilized? Does a drug test accurately measure current substance abuse versus residual? What is the actual work site? By that, you've got people who are working remotely. I've got an example. A business I run has employees that are across the United States. Where the employees remotely log in is their place of employment. That's where you pay their taxes, their state, local employment taxes, unemployment insurance. Basically, what I've been telling the employers I work with is if that employee regularly works in a state to where you're paying unemployment, that is their place of employment, not where you're headquartered. But the other issue is, what if they are traveling into different states? Do you have to comply with those states? If you are in the state of Kentucky and the person's traveling to Arizona, do you have to comply with both states, one state or the other? And there is no answer to that right now. And we're going to talk about why there's no answer here in just a second. So big questions about, whoops, let me turn on my highlighter here. Big questions about where the actual work site is. And, if they're working remotely and report to a Kentucky-based facility, when do they touch on the state of Kentucky? When can you test and when can you not test? What state controls, what state doesn't control? Those are serious implications, serious questions, and some of these do not have an answer, like Lyle said. The other thing that, for anybody that's over the age of 25, the federal government has made marijuana use illegal. if you're over the age of 25, we all thought we all had to follow the federal government. And because it's illegal under federal laws, surely to goodness, we're not going to have any state laws that would adopt a drug policy that says we don't care what the federal government does. The irony to all this is one of the earlier states, not the earliest, one of the earlier, because California, Arizona, Nevada, Washington, Oregon, those were the first states, and it kind of filtered across. But one of the earlier entities, not states, that adopted the policies of no drugs are illegal or no marijuana is illegal was Washington, D.C., which has no state, which is nothing but a city and is governed by federal law. So you want to talk about a bizarre situation that one of the companies I run is in D.C. area, what we call DMV, D.C., Maryland, Virginia, little corridor there. And inside that area, if you're on federal property, it's absolutely illegal. You can get arrested. If you're not, the police won't do anything. And so the smells, the sights, everything in DC is just bizarrely crazy. It's under federal law, but the local government won't do anything about it. So these are the myriad of issues that we're concerned about, why I thought we needed to address the issue. So the basics, let's talk about Kentucky. It's kind of bizarre because if you look up the various marijuana legal websites, you'll see on there that Kentucky is now listed among the states that have legalized marijuana. And you go, wait, what? And they haven't. But what they're doing is any hemp product that has hemp at all, product that has been legalized is now considered by the various entities that are pushing for or monitoring marijuana use to be the entry-level toe in the door first step to getting legalization of marijuana. Kentucky has only, and this is the Farm Act of 2018, or the Farm Bill, CBD less than 0.3% THC by dry weight is the only thing that's legal in the state of Kentucky. But when you pull up a map, let me see if I've got it. Yeah, here we go. We pull this down here for you. This is an organization that is the National Council of Conference of State Legislatures, and they have their map. And if you zoom in on this map, Kentucky shows up as being CBD low THC program. So we used to be over here with Kansas, Nebraska, and Idaho as the only states that didn't allow. This is kind of a new thing that they're now pushing, saying, well, CBD equals THC just in a lower form. So it's legalization of marijuana. So now we're on the side of apparently somewhat in between. State legislature in Kentucky has repeatedly attempted to look at this. There's a group that keeps pushing for it to be legalized. The last time it was actually up was in 2020. It was adopted by the state house, but it died in the Senate committee before they closed, and then it just wasn't brought up in the 2021 short session. It's a matter of time, probably because of all of the other states and the fact that Kentucky actually used to be one of the original marijuana and hemp growing states. So it's a matter of time before it comes into play again. Keep in mind, certain public sector positions are governed either by state or federal, like the Kentucky State Police, and any non-sworn officer, meaning any private citizen working for the state police, can be randomly drug tested for reasons that they believe that this is an important thing to make sure it doesn't get in to the state police system. So they have drug testing policies and so on. FAA, which you just heard, I'm glad I put it in there because the FAA with Bluegrass Airport, they have their own policies and procedures you have to comply with. Any federal agency, any federal grants, any federal institution monies. So it's interesting, one of the areas I like to go to, there's a Midwest university that has absolutely incredible policies and procedures that are out there for the general public to look at. They're in Word, they're in PDF. I use it all the time because They have a team of attorneys because they have a law school, and they have incredible policies and procedures. They're always up to date, and I love to go out there and look at them. I'll go ahead and tell you where it is. You can feel free to go look if you can find them. It's Oklahoma University, or the University of Oklahoma. They have an incredible resource of policies and procedures that are directly on point. If you can find them, and if you can, you know how to navigate it and look through it. But sometimes if I just am trying to figure out something, I'll go to look at theirs and go, oh, wow, that's an idea I hadn't thought about, and I'll incorporate it and talk about it and so on. So that's an area you might want to look into. If you are running a university, college, or anything that gets federal monies or grants, if you're on a federal contract of any type, then you do not get to adhere to all of these myriad of states that are doing different things. You must comply with your federal contract or with your grant funding, NIH grant, NSF grant, any of the others. If you're receiving federal monies, you cannot allow any drug use. So like the reason why I mentioned Oklahoma, they have a policy that says, yes, we're aware that Oklahoma has made medical marijuana legal. We don't care. Employees, students, you cannot use on, if you're living in a dorm or any facility on campus, you cannot use. Employees, you're subject to whatever drug testing policies are under our grant funding, our contracts with the federal government. So anyone on this call that has any involvement with a federal contract, you have to pull your contract and verify you're in accordance with that. You cannot follow the state laws. If any of this applies to you, the coal mining employers with an employee assistance program, you get certain credits. There's a certification program for drug-free workplaces. All marijuana is illegal in Kentucky. CBD derived is not. That is what's causing the potential issues that you just heard from the Bluegrass Airport. Just by way of an example, really quick, I had a question asked. Someone came into the state with a medical card and wanted to apply for a job. They came from Michigan. And the question was, do we have a right to drug test? Yes. The second question was, well, this person tells us they're going to test positive, but it's because they legally had the drug card in Michigan, and this is before Michigan adopted the recreational, by the way. They only had medical up until 2 years ago, I believe. So the question was asked of me, so can we refuse to hire this person because it's completely legal, but they're going to test positive? My answer was absolutely. You don't have to hire the person in the state of Kentucky at that time because Kentucky has no leniency whatsoever for drug use, and the person was going to be physically reporting in the state of Kentucky. So in that instance, we gave the guidance that said, feel free not to hire the person, it's up to you. So we've talked about the THC. We're going to skip that for a minute. Here is where it gets a little interesting. First, OSHA 2016 published a final rule that removed a certain section that they used to have, and it then said that employers are prohibited from retaliating against employees for reporting work-related injuries or illnesses, including drug testing. So what this did was it prohibited drug testing of people who then said, well, I just caused this accident and I don't want to be drug tested because I'm going to test positive. That's not exactly how it all plays out, but you can't retaliate against the person because they happen to test positive unless you can demonstrate that it was on-the-job drug use. Then you have, like Allison talked about, if it's active use, you have the ability to take action. The problem here is we've always talked about objectively handling employee disputes and not subjectively doing things. This now brings in the subjectivity to the manager, and that's where you're going to have a whole lot of training on managers, especially in a factory situation. I've had forklift operator drug testing for running over somebody's foot. I've had all kinds of things, and they've come back with all kinds of results. And the law is changing as to when and who and why you can drug test people. Federal law, Supreme Court has said drug testing does infringe on an employee's privacy. However, if there's reasonable suspicion, you have the ability to drug test to protect the health and safety of others. So the Supreme Court weighs in, says you can do it, but you have to be careful about what is and is not reasonable suspicion. So if it's so stringent in Kentucky, why do we care? 36 states, and I went back this morning and recounted. I actually think it's 37, but I went with 36 because I can't tell whether Virginia is or is not yet included because it doesn't technically take effect until July 1st. So it's illegal right now for another 10 days. It will be 37, I believe, and it will be 18 starting July 1st. 36 states have legalized marijuana. That is not CBD. That's not Kentucky. That's not the surrounding. And just to bring it back up so you can see what we're talking about. That is not any of these light colored states: Texas, Kentucky, Tennessee, Mississippi, Georgia, South Carolina, North Carolina, Indiana, Iowa, Wisconsin, or Wyoming. Also New Hampshire and a few others. Actually, no, those are darker green. So this does not include those. This is only marijuana use. 36 states have adopted it for for medical, 17 for recreational. Creates a lot of issues. So a hypothetical I want to throw out at you. An employee works for a Kentucky-based company, paid out of Kentucky, but resides and works remotely in Virginia. Can the employer restrict the employee's use of medical marijuana? And the answer is, well, yes, for the next 10 days you can. After July 1st, no. Virginia has legalized marijuana use for recreational purposes and medicinal purposes. And it has protected employees from potential retaliation for recreational use. Now, the bizarreness of this is this. It did not. The bill that got passed that's coming into effect on July 1st does not protect employees. It literally says employers can take action. However, a different bill says, unless of course it's THC oil. So if you use oil and not smoke it, nobody can retaliate against you. And I asked a person who runs a company, it's completely legal, in one of the states that has medical and recreational, and he runs a facility that is involved with that. Is there any drug test that tests smoking versus oil? And he said, absolutely not. It's all the amount of THC in your system. Now, if you smoke it, it doesn't stay in your system as long, and you're going to see that here in a minute. The way that you digest things will affect how long things stay in your system. But the effect of these two bills together in Virginia is basically you can't drug test somebody who's an employee. You can't retaliate against them. I'm sorry, you can drug test if there's a workplace, but you can't retaliate for recreational use because we can't distinguish between oil and smoking, ingesting, or any other use because there's no way to differentiate between THC from different methods of ingestion.
Different sources.
So,
Different sources.
Different sources. So if an employee resides and works locally in Virginia, the employer cannot take adverse action based solely on a drug test because you can't retaliate. It's different if they're working in Kentucky and living in Virginia. So anyone along the eastern side of Kentucky that's dealing with that it's going to be a completely different scenario. We're going to have some real problems in trying to figure out how to handle somebody who lives across the border in Virginia, works in Kentucky, tests positive, doesn't work in Kentucky, when they aren't working in Kentucky, and when they are. There's a lot of stuff we're going to have to work through. State by state, I'm not going to go through these in a whole lot of detail, but this one is pretty important for multi-state employers. Arizona, Arkansas, Connecticut, Delaware, Illinois, Maine, Minnesota, Nevada, New York, Pennsylvania, and Rhode Island have actually adopted, and then Virginia. These have actually adopted anti-discrimination provisions. One of the biggest ones is Arizona and Nevada. They literally have adopted, you can't take action against the employee for the employee's use. Delaware joined that. Maine is ridiculous. It actually is the most lenient in the country, with the possible exception now of Virginia. But it literally required employers in Maine to stop drug testing job applicants for marijuana use, prevents employers from firing workers 21 years and older for the use of marijuana outside of the workplace. Along those lines is what Virginia's done with this medical oil. I'm sorry, with the THC oil, got medical in there by mistake. So it's going to become a real problem for you. Additionally, localities are passing a lot of these laws. So for example, Denver is one of the most insane localities, along with San Francisco and New York City. But Denver allows mushrooms right now, in addition to marijuana. I didn't put that on here because that just goes without saying in Denver. Meanwhile, Boulder took the other side and said, no, we're going to allow specific drug testing, and you can do as much as you want, drug testing. San Francisco prohibits all random drug testing altogether. New York City went further than New York, except New York just now adopted in March of 2021 a recreational and medicinal drug testing, so it's now joined the whole thing here on March 1st. It's so quick with so many. I've already talked about this with Virginia's laws and what they've done. I'm not going to go back through it, but it's what they don't allow and what they do allow. I do want to point this out for anybody on the Eastern Kentucky side. It's supposed to not restrict an employer's ability to take any adverse employment action for any work impairment. It does not require an employer to commit any act that would cause the employer to be in violation of federal law. I've heard that over and over again. The problem is that federal law bans marijuana use. And almost every state that has legalized marijuana says that they don't quote, require an employer to commit any act that would cause the employer to be in violation of federal law. You mean like allowing the use of drugs? These laws are not making sense with the federal government not in step with the states and allowing the states to make the decisions. So there's a lot of inconsistency going on. But this is where there's a question in the chat, and this is your answer. This isn't just Virginia. I know this is a Virginia law, but you can't take any action against any employer if it would result in the loss of federal contract or federal funding, because you must comply with federal law in order to maintain that. It also, the next one talks about, that's basically the federal basis. But the last one is what's insane about Virginia and some of these other states. There's no carve-outs for safety-sensitive positions. Physicians, nurses, EMT, police officers, sheriffs, judges. I don't know the judges are in safety sensitive, but they literally are not carving out. They would allow people to use marijuana without any limitations and without any drug testing in the state of Virginia now, right next door, for police officers. It's a little bit of a problem, and it's going to only get bigger, and that's why I made the comment at the bottom. I won't read it out to you. All right, following states have no protections for employees, and I just listed them there. I'm not going to go through them all. The first bullet allows all medical and recreational. The second bullet allows medical, and the third one, I don't know why it's even there because it's up above. So I'm sorry, Massachusetts shouldn't be on its own down there. California is discussing employee protections. It has adopted some, but some of the others are a little bit up in the air. Ohio took the opposite approach, which if Kentucky adopts, I think it will be what Ohio did, which is you have free reign as an employer to do whatever you want and to fire anybody you want. And if they use drugs and you don't allow drugs, go ahead and build your policy. I think Kentucky would do that if it adopted the laws. Other states are changing daily. Cities are changing daily. And then the last bullet down there about Florida, Louisiana, New Jersey, and North Dakota, they left the regulation up to an administrative agency after they adopted medical and recreational. And they haven't yet adopted what they're supposed to do with employees. So keep that in mind. Still unclear. What if you work in multiple states? One allows and one doesn't. How do they apply if they live in one state and work in another where it's legal? Multi-state employers must address employees differently depending on where their work is being performed. And employers must be up to date constantly with federal, state, and now even city-specific laws, workers' compensation laws, employment laws, anti-discrimination, and so on. Welcome to the craziness. So this new landscape. First of all, what's the level of tolerance that you're going to allow? And you can establish that to a certain extent unless you work in an area regulated by the federal government. Drug testing policies will need to be reviewed to remove zero tolerance because Kentucky doesn't have zero tolerance. Unless, of course, you want to go beyond, and like I said, Kentucky allows you to drug test if you want. If you want zero tolerance, even though there's a 0.3% THC and CBD oil, that's your decision right now in the state of Kentucky for a Kentucky employee that works in the state of Kentucky. If they work anywhere else, then you have to address the issue for the other states. Discussions need to take place regarding potential disruption for strict marijuana use. You need to start talking about it. You need to have a plan in place. I would not utilize the internal drug testing schemes or rapid result tests. I talked about that earlier. Highly recommend a third-party facility, and I would highly recommend investigating and scrutinizing that third-party facility. Have frank and open discussions with your third-party facility to address the specific levels that you allow, the expectations, and verify what your company and or federal authority, state authority is authorizing for those limitations. You need to then have open discussions and expectations set with management and employees because as this becomes more prevalent, you're going to have more instances, and you also need to be keeping in mind the negative impact of having a harsh rule, because what if your best performer went on a trip and ingested accidentally or purposely or didn't even realize what it was, where it was, whatever. If you have to follow the golden rule. If you do this and that person is testing positive, then you're going to have to fire one of your best performers. So you're going to have to start thinking about it. As more and more products contain THC, CBD, hemp, and other materials proliferate our area, you need to reevaluate your expectations. You can now walk into a Walmart and buy the CBD oil. You can walk into a Walmart and get it. You can rub it on your skin. You can swallow it. You can put it under your tongue. You can use it in your hair. It's supposed to make your hair incredibly awesome. And so does that show up? I would not recommend you do pre-employment testing. Do post-hire pre-placement evaluations. Now that does create problems because I've had employers go, wait a minute, if we hire them, then we fire them. Are they on our unemployment? What does this do for workers' comp? All legitimate questions. I'm just telling you, if you're going to do drug testing, I would not do it pre-employment because there are a lot of limitations on pre-employment, on HIPAA, GINA, employment discrimination, anti-discrimination, so on and so forth. You need to constantly reread, review, and update your policies and procedures, always. So, here's your little background on drugs and drug testing of marijuana. There are 4 different ways to drug test: saliva, urine, hair, and blood. Saliva test is the one that I would recommend most people utilize right now because it's limited to the 34 to 48, and it's the least invasive. Urinalysis testing could include up to 21 days for a moderate user, more than a month for a heavy user. Infrequent user would show up for 1 to 3 days. If you digest it instead of smoking it, it may produce a positive result for up to 5 days. So that's the urinalysis. The saliva, like I said, typically is just 34 to 48 hours. Hair test, 90 days. That's the least viable right now, because what you all should start to look at, regardless of how you feel about marijuana use, as an employer HR, my recommendation is you now need to look at active use, not hair follicle, because that's a historical. Now, if you're trying to prove that somebody was using in the past, great. That one will show for up to 90 days. There have been questions asked lately about the hair as to whether it will actually test for infrequent to moderate use, or whether it's just picking up heavy use over the lifespan of the person's hair follicle. So keep that in mind as well. Blood test is the least in terms of time frame, but it's also the most invasive because you're actually drawing blood from the person. It's a 36-hour. It's the one that I highly recommend you use post-accident, because it's the least challengeable, the most accurate for current use. So that's the one that I would utilize if I were you. It's also the one that you can have multiple tests done if somebody challenges it. Besides the type of test, there are so many other variables with marijuana versus other drugs that it's insane. If you haven't gone into or looked at the number of different strains of marijuana, it's insane. I'm not suggesting you do it, but there are ones that don't have any residual impact, but they have all kinds of medicinal. There are others that have no medicinal, but they'll make somebody as high as a kite. They call them everything from the Puff the Magic Dragon to whatever you can come up with on the other side. But it literally depends on the amount of THC in the marijuana, the frequency of the use, the length of the time that you, in between the last use, how quickly each individual person's system processes THC versus other parts of the marijuana, the level of hydration of the person at the time of ingestion, as well as at the time of the test. I mean, it's all over the map, which is why marijuana testing is so scary. And just like they said with the Bluegrass Airport, how do we tell? Go beyond this and talk about the Kentucky Derby with a horse that happened to be tested, and we've all heard about it. And you have challenges because it was in the lotion that was used on the legs of the horse, and now they're challenging the whole result of throwing out the Derby. It's the same kind of thing. If you're taking hemp oil and you're rubbing it on you as a lotion that has THC at a very low level, you're ingesting it as CBD oil. It has under the tongue. By doing it under the tongue versus swallowing a pill, that can make a difference in the level and the timing that it's taking with being absorbed into the system. So there's a lot of issues with that. So here is the answer, hopefully, and I don't know if you've looked into this particular one. I'm not a LabCorp representative. I'm not here to try to tell you to do this, but LabCorp was the first one to come out with a new testing that actually determines between CBD and THC. It literally will determine whether someone is getting, now there are some questions and answers. I don't have that screenshot on here. No, it wasn't a plant. I didn't know that she was going to talk about a particular issue with CBD versus THC. So this is kind of cool to have somebody actually give us a real life scenario. And I actually was researching the same issue because I deal with all kinds of manufacturing companies across the Southeast and trying to keep from getting in trouble with these various laws, but still keeping track of people doing illegal activity while they're able to have their arm chopped off on a machine, on a stamping machine, or the automotive line in Georgia that could destroy somebody's life or someone else's. So there are some tests available. that test the ratio in someone's urine of cannabis CBD, cannabidiol, let's go with CBD. And I'm not even going to try the tetrahydrocannabidiol, THC. So I would investigate that, and I would contact them and others if you're using a different testing facility to determine, because they actually can figure out. The concern that you legitimately should have is the gateway issue, which is people can now say, no, I'm not taking THC. I'm taking the legal CBD over the counter, and you can't fire me because the laws allow me to use it. Well, the laws allow you to use it, but if you get above the 0.3% in your system, that is illegal under the state of Kentucky, and you got it somehow. It's kind of like drinking a beer. You can drink a beer in the state of Kentucky if you're over the age of 21, and you can still drive a car. You drink 2 beers, you may not be able to drive a car, but you can still try it. You drink 4 beers, chances are you're going to be above the 0.08, and you're going to get arrested if you get pulled over. You can still do it. You can still drink a beer and drive a car. It's illegal. You can still take cannabis, CBD. You can still rub the lotion, wash your hair, put the oil under your tongue, swallow the pills, and do everything else. But if your system shows above a 0.3, you took too much and you are now above that system. So that's the issue you're going to have to deal with. Third-party testing companies, those are the ones I would rely on. The difference between the two, this one in particular seems to be doing a good job with it. Investigate your current requirements, especially the airport with the federal. Forget the state. If you're governed by federal, don't worry about the state or the local, because all you're doing is federal. So FAA, you don't care what the state says. Same thing with the industry, medical industry. If you're governed by the federal government, you don't care what state says. Make sure you maintain confidentiality. Remember HIPAA. Remember GINA. Don't do anything that would cause any issues with that. So that's that one. I'm going to try to fly through this, and I know that we're at the 1 hour time, or close to it. Yeah, we're at it. But this is critical stuff for you all as well. No, it's not COVID. Yes, it was all caused by COVID, but we're going to roll right into it. Then we'll answer questions after we're done. So, EEOC, you'll understand why I went in this order once you see that the order is what it is. Yes, the biggest one for you is OSHA. The ETS did come out finally on June the 10th. So did the non-ETS. For those that haven't been on, ETS was the emergency temporary standards that have been scaring us to death. They did come out with those. They don't apply to you unless you're in the medical field, but then they came out with recommendations that do apply. It all kind of comes together with the EEOC first. So the EEOC came out at the end of May with their much needed guidance. They changed some of the things we talked about in the middle of May. First, the federal law does not preclude employers from requiring all employees physically entering the work site to be vaccinated. What that means is if you as an employer want to decide that 100% of the employees must be vaccinated, you can do that with exception. Can't do it for disability, and you can't do it for religious. Religious is your nightmare. Disability is just the ADA. You have to come up with reasonable accommodations. Religious is bizarre, and we've talked about it before. I'm going to talk about it just a little bit here. Religious is anyone's firmly held belief based upon God or the absence of God, belief or the absence of belief, thought or the absence of thought. In other words, if you have a savvy employee that says it's my personal religious belief, it's not adopted by the Catholic Church, it's not adopted by the Presbyterians, it's not adopted by the Muslims or the Jewish or anyone else, but I personally, in my religion, believe that I shouldn't be vaccinated, or anything else, by the way, not just vaccinations. If they have a personally held religious belief, you must accommodate that person. So in other words, if they're savvy and they say, oh, it's my religion, key word to you if they say anything about their firmly held belief or religion, passion, anything like that, do the reasonable accommodation. You can incentivize. This is another change because the new administration came out and said you couldn't. They reversed course and said, yes, you can within reason. If you encourage people, $75, $50, free pizza party, you have to do other incentives for those that can't because of religion or disability. And also, if you go too high and it's no longer the employee's own personal belief, but they're being coerced by you, and monetary can be that, then you can't take action against them because now you are usurping their decision to disclose disability-related screening information involuntarily. So that's the problem, and it just came out. It offers some additional guidance with regard to reasonable accommodations, and basically what it is no new news. You just have to allow social distancing, allow them to telework, masks, screens, all the other things that we've already talked about for a year. So anyone that has a sincerely held religious belief or disability, you have to provide those accommodations. You are not allowed to volunteer. This is brand new. Kind of surprised me they said it, but employers cannot offer employees incentives for vaccinations of family members. So like some of the bigger companies were like, wow, how about we offer this to families so that we keep people healthier, their families healthier, they're on our health plans anyway. No, can't offer any incentives for vaccination of family workers. Their rationale is it might actually get into someone's GINA protected information, which I thought was odd, but who am I? It's just the EEOC. They did say that vaccination status is confidential medical information, which is odd and bizarre because you'll see here in a minute, OSHA says you have to screen your employees and you have to protect those that have not been vaccinated, and you have to ask for, or you can ask for their vaccination status by looking at their cards, their doctor's notes, whatever else you want. And there was even talk about, so maybe employees should wear green bracelets if they're vaccinated and red if they're not. Well, how do you do that if the EEOC confirms that your vaccination status is a confidential medical information that can't be shared? I don't know. I've gotten so many questions over the last 3 weeks about, wait, how in the world are we going to comply with OSHA when we are told we can't screen people? And the answer is, good luck. Sorry, that's my sarcasm for the day. They have now come out, though, and said, well, you know what, all of our pre-screening concerns that we had before, they don't really implicate GINA or ADA. Feel free to ask the questions, whether you're the employer providing it or you send them out to a third party. They can ask any pre-screening inquiries that they want, and it does not implicate ADA or GINA. That's a flip from what we talked about in April. Voluntary vaccinations for certain employees is acceptable as long as you do not do it discriminatorily. In other words, you could say, look, I want all my managers to get vaccinated. I'm going to pay for them. I'm not paying for anybody. I know that we've got free vaccines everywhere. I'm not suggesting that. But you can actually dictate certain groups of people that have to be, certain people that you're going to pay for, certain people you're going to give time off for, as long as it's not done discriminatorily. OSHA. No, this isn't the big one. This isn't the ETS. On May 21st, OSHA reversed course of the April enforcement that we talked about. If you go back to April, early May, middle of May, I had some talking points for you on why you didn't want to have a vaccination policy at work, because if somebody got sick and you're the one that mandated it, you had to report it to OSHA. It was a workers' comp issue. It was a workplace issue because you mandated that they get vaccinated. They got sick. You had to report it on your logs. It made your insurance go up. It made other issues occur. You were required to put it on your record-keeping logs. On May 21st, what was going on is literally the government's realizing that they're not getting employer buy-in because they basically threatened employers with retaliation, discrimination with GINA and ADA, and OSHA concerns, because if somebody got sick and you're the one that sent them to get their vaccine, then you had to put it on your log. So then they came out, reversed course. It was really super quiet. They just deleted it from their website. And then they said, and I quote, "OSHA does not wish to have any appearance of discouraging workers from receiving COVID-19 vaccination, and also does not wish to disincentivize employers' vaccination efforts. As a result, OSHA will not enforce the regulation, recording requirements to require any employers to record worker side effects from COVID vaccinations through the end of May 2022. We will reevaluate the agency's position at that time to determine the best course of action moving forward. It also reflects that the previous enforcement is, quote, archived as of May 26th. So they reversed course, announced that you no longer have to report that. That's important because now you can incentivize, you can mandate, you can require, and there are no OSHA side effects from doing so. Now the ETS. And we're getting into the meat of this, but it all kind of flows because it all adopted previous guidance of EEOC, and they all kind of built on one another. So the ETS came out. This is a nightmare for anybody that is governed by this, but they then said only for medical institutions. It applies to all settings where any employee provides healthcare services or healthcare support services. Then it defined it. You know it if you're in it, so I'm not going to read that. Healthcare support basically means anyone that's involved in anything that's related to healthcare. So laundry services, medical waste, equipment, food, anything. So just, you know it if you're in it, and if you are, you need to get up to speed because it took effect immediately. June 14th is when it went into effect right here. It does not identify how a medical facility determines full vaccinated status, and you're going to see that here in just a minute. Fully vaccinated status is a big, that's the red bracelet, green bracelet issue and concern. It also talks about things that are excluded, things that are first aid, pharmacists in a retail, fully screened, non-COVID, non-hospital ambulatory care, well-defined hospital ambulatory that excludes COVID people, home health care that excludes COVID. There's all kinds of exclusions to this. Goes into effect on June 14th because that's the date it got adopted. June 28th had certain things. These are all things you have to do. If this applies to you, call your general counsel. If you don't have general counsel, you need to get one, or you need to get an attorney to help you with all of this, because every single one of these semicolons are separate things that you're mandated to do by June 28th. So in other words, next Monday, you have to have in place and you have to produce to the federal government within 24 hours notice all of these things that are building on the COVID-19 in a healthcare facility. Physical barriers, ventilation, and training, they gave you 1 month from adoption, 30 days. So it's July 14th, which I believe is a Sunday, but that's the date of compliance. All ETS requirements are implemented at zero cost to all employees. So if you're in the healthcare industry, don't try to charge your employees for any of these things. All training is the biggest one that's new. You're going to have to do that for temporary employees, it's across the board, and there's a lot of things to it. But the ETS was supposed to be nationwide. Luckily, as vaccinations went up and the COVID went down and so on, they made it only medical. It's why it took 6 months to adopt when it was supposed to be adopted within 30 days. They could not keep up with the changes, so they just made it medical. So non-medical. So you ask, well, what about us? Well, they came out with the same day with a non-medical COVID-19 guidance. The first thing here is the question that I asked, and I've seen several people ask, is it even enforceable because it's recommendations and guidance but not enforceable? The answer is It's only enforceable under the general safety regulation where all employers must provide a safe environment for their employees. So the very vague OSHA general protection. So what did OSHA do on the 10th? They adopted CDC's May the 13th and May the 23rd guidance related to fully vaccinated employees. Basically what that did was fully vaccinated individuals, quote, can resume activities without wearing masks or social distancing. And then this policy actually said, except for workplace settings covered by the new ETS and mask requirements for public transportation, which is your airlines, buses, taxis, Ubers, and all the different things that the federal government hasn't changed yet, but I suspect will change by the end of June. Most employers no longer, this is a direct quote out of this, no longer need to take steps to protect their workers from COVID-19 exposure in any workplace or well-defined portions of the workplace where all employees are fully vaccinated. Where all employees are fully vaccinated. So that's the problem, is they didn't tell us what do we do with those that aren't, or we don't have a clue whether they are, et cetera, et cetera, et cetera. Well, they didn't give us a whole lot of information. Let me walk through this really quick. They recommend that employers encourage employees to get vaccinated with time off, paid time off to do so, and also allow them to recover from potential side effects. They then instructed on unvaccinated at-risk workers who have had close contact, requiring social distancing, providing training in all appropriate language, maintaining ventilation systems, following CDC guidelines, and protecting employees from retaliation. And you all have to provide and establish an anonymous reporting system similar to your sexual harassment hotlines so people can report that somebody's not adhering to the COVID. That is a mandate now under OSHA if you're following this guidance and you believe that it's enforceable under the general provisions. Unanswered. How must employers, and I'm saying this for the group that I must have gotten 12 emails in the last 2 weeks, how are we going to verify vaccination status? And how do we determine that somebody is or is not? Well, hidden, yours truly had to go find this for you. This is your dedicated employment attorney. Page 662 through 663 of the preamble to the emergency temporary standard. Let me repeat that, page 662 of the preamble, not of the ETS, of the lovely red tape that our government likes to throw at us before they even get to the standard. Page 662 and 663 said, and I quote, OSHA suggests, quote, in order to make the determination of which workers are fully vaccinated, employers could, for example, vaccinate their workforce themselves. EEOC recommended you don't do that yourself because to do so could well implicate GINA, not the pre-screening that I just talked about, but the actual testing could implicate GINA and ADA. But now OSHA says you could do this yourself. Or you could review CDC vaccination cards or similar verification issued by a pharmacy, healthcare provider, or other vaccinator, if available. You could also review state-issued passes or simply ask the employee to attest whether they have been fully vaccinated. If the employer, this is the kicker for those that have asked, if the employer is not able to determine that an employee is fully vaccinated, the employer must treat that employee as not fully vaccinated. Now, the other caveat I have for you is this was in page 662 of the preamble to the ETS, which is only medical. It's not clear whether this statement applies to the guidance for non-medical or not, although you would presume that it would because it's basically the same language, i.e. those that are not vaccinated and how you should handle them. So that's the update from OSHA. I'm not going to spend a lot of time on this because I've gotten 0 comments on it, but if this is important to you, be careful to look into it. The IRS finally provided guidance on the COBRA extension. If you're not familiar with the fact that COBRA is 100% subsidized between April the 1st and September 30th, you need to be. They issued, and I'm not kidding you, and no, I didn't read it every single one because I hate taxes. 86 frequently asked questions regarding COBRA subsidies. 86 questions. I breezed through them. I flagged the ones that were critical. I did not read every single one. It's a nightmare. But they waited a month and a half into this to even provide the subsidy guidance. They have all kinds of things in there about an individual may become an assistant employee in need, AEI, if he or she or a spouse experiences more than one event, you can require an employee to self-certify. You must maintain those documents. You may be eligible for the subsidy even if the reductions were voluntary. It talks about involuntary termination and what that is and is not. It provides the credit is either on a 941 tax form or there's the brand new advanced payment of employer credits due to COVID-19. It's included in the gross income of the premium payee, i.e. the employee. Whoever is paying the premium or getting the premium paid, it is taxable. And a third-party payor, such as a PEO, which is a professional employment organization or a certified professional employment organization, or an agent may also claim. Last bit of news, just a couple things I've been warning you about. First of all, the EEOC conciliation rule is being revoked. It's been voted on by the Senate. The House is voting on it now. As soon as they get to it, it'll be done, and the administration has indicated it will sign it. What this does is it strips away the transparency of the EEOC for employers. It did provide employers with more information during the conciliation process. It required the conciliation process, and it required notification as to why they were investigating. They no longer have to do that. And then the union transparency rule is being voided. Comments are being accepted through July 26th, but then it will be voided. This was put into place in 2020, and now it's going to be scrapped, so there's no transparency in unionization efforts, which is something that we've been cautioning you on as well. The unions are coming. The protections for employers are going. If you're not familiar with that and you don't realize that you could well be unionized, you need to be very careful to have well-established policies because there's no protection for employers right now. That's it.
Jim, thank you. There were a couple of questions in chat. I think you got them, but last one I noticed from Lindsay Witt. No, let's see. There's some more after that.
Well, there's one before that. Anti-discrimination waive for certain jobs. Truck drivers are governed by their truck driving license and their federal certification. So if you are getting a CDL, the CDL commercial driver's license has certain protections built into it that would apply instead of state laws. So if there's something with a specific job that has federal oversight, airlines, bus drivers, CDLs, taxi drivers, which is one reason why you might want to consider, and I'm on the other side of this, but you might want to consider taxis instead of Ubers. I've been asking since the first day I used an Uber, do you realize that Uber drivers have no protection because they're driving a car with you in it without a commercial license? Their private insurance is not built for a commercial purpose. If they don't have commercial license, you're basically in a car without insurance, trusting somebody you've never met before to drive you around. Yes, I still use it because they're a lot nicer than the yellow taxis that you can find, but just be aware that you're taking your life into your own hands. Sorry, so Lindsay's on there. Return to work, second chance. So, okay, the return to work with second chance for someone who failed a drug test. Wow, you're getting into a lot of issues. There is no state protection in the state of Kentucky, but under OSHA and under some of the federal, if somebody were to come to you after you tell them you have poor performance, and they say, I have an alcohol problem, before you fire them, and they say, I have an alcohol problem, then you have to then consider that to be an ADA, because it is a drug use, alcohol use is a protected, if it's disclosed to the employer, it becomes a protected disability that you then have to accommodate. So when the person comes back, you have to allow them the opportunity, but it kind of depends on the conciliation process that you engage in at the ADA, your investigation of their concerns. They don't have to come straight out and say it, but if you believe that it's impairing their work and they didn't cause injury. Now, if they are a forklift driver and they ran over somebody and they were as high as a kite, you have the ability to fire and take adverse action against them. But you do need to make sure that you're in accordance with your policies, your drug testing policies, your handbook, and whatever state that person is in. So the second chance laws really pertain to both the federal ADA. Did the person disclose to you, or did you have reasonable belief that they had a disability, i.e. a drug or alcohol issue? And then did you take adverse action against them, and do you have to take certain steps to try to assist them? I hope that that answer is kind of a long question. I'm trying to read it.
All right, I want to wrap up because we've run quite long. Gosh,
Yeah.
when we started this, when we started putting this together, we didn't know there'd be that much stuff coming out. But I have two other things I want to mention that we're going to cover in the future. One is, I know everybody's having a struggle hiring people. I suspect, we know, all of our clients are. We have 4 full-time recruiters and they can't even find everybody we need. So part of that is this whole unemployment thing. And the governor came out with a statement on it on Thursday that he was going to continue to do the extra $300 because he thinks it's good for the economy. But he did agree that he would try to find some incentives to get back to work. And that's something that we've been writing him about. I know that you all are struggling with. So we want you to know we're staying on top of it. But that leads me to a second issue, and that is pay inflation. I suspect you're seeing some of that. It's hard, especially at the lower levels. It is very hard to get people to work now without paying them more. Even McDonald's is giving extra money. They're doing, incentives for paying back college loans, a lot of things going on. And so we're going to have some follow-up issues on both of these, or follow-up calls, or Zoom calls on both of these issues. We're right in the middle of the comp stuff because we do that every day for people, and we know those numbers are changing, and we're getting a lot of calls on it. So we'll try to share some of that stuff with you in the future too. I hope everybody's enjoyed this. It went a little long. We are going to send out codes, but we didn't have them here. We got kind of behind on that, but we'll have something for you shortly when we send out the summary of the call. So any final words, Jim?
No, I'm sorry it went long, guys, but there was a lot to cover on the various issues we were trying to cover, and I appreciate everybody listening in.
Yep. All right. Let's open it up in case anybody wants to say a word, but otherwise we have concluded the Zoom call information for today. Can you